Donald Trump appeals the Colorado ballot removal ruling, but only a portion of it because he pretty much won it. They wanted to get him off the ballots. The judge says no, the 14th Amendment insurrection clause doesn't apply to the presidency. But there was that little problem that the judge had in her ruling, saying that Trump is in fact an insurrectionist, saying that he kind of led an insurrection. There was in fact an insurrection, and she spent a lot of time talking about how he's a criminal, essentially somebody who was undermining American democracy and so on and so forth. And so obviously Trump doesn't want that precedent to stand. And so he has submitted a notice of an appeal in Colorado to the next higher court. And we're going to go through that in detail. But he's not alone. The people who wanted him removed in the first place, we're calling them the Colorado Removal-Petitioners, the people who don't even want him on the ballot because they're like, he's so dangerous to a democracy. We can't let Americans vote for him because if they do, maybe they'll put an insurrectionist in the White House. What? All right. Whatever that logic is. They say we can't even give people the choice. So we're going to remove him. And they also submitted an appeal saying that no, he is an insurrectionist. You got that part right, Judge, but the part you got wrong was that the 14th Amendment doesn't apply to the presidency, to the office of the presidency. Now, the Supreme Court there in Colorado has accepted this. We'll take a look at what the calendar says here on what the briefing schedule is as these appeals move forward, because Trump's not done yet. And then we'll hear what one of Trump's attorneys, who actually argued the case in Colorado, said, because he showed up on CNN and got into it a little bit with Caitlin Collins. And so we'll start right out by seeing what the petitioners said in the first place, because we know that they are unhappy with the ruling. They obviously want this to go the other way, and this is what they have in their filing. Now, again, this is the Supreme Court in the state of Colorado, which is where they're submitting this, and this is just the opening salvo. When we get the appeal process underway, generally two parts. One is you kind of submit a notice that you're appealing. Hey, this is what's coming up. This is the issue, and so on. And then you'll submit more, bigger brief. Once the court grants you permission to actually be there, then you say, okay, now we're going to really beef up our original filing. So one's like a notice, and then one's like the actual brief, and that's really where the meat is. So here we see these are the petitioners and the respondents. Of course, we've got the interveners, and this is Trump and the Colorado Republicans. And we're now at the Supreme Court in Colorado, and they write the following. They say, all right, petitioners, meaning the removal people, they file this notice. We're upset. We're appealing the final decision of Judge Wallace in Denver. Now, this is an expedited matter and requires expedited briefing, man. We've got an election coming up any minute. We got pending deadlines for ballot certification. They want to keep Trump off the primary vote, and they've got potential appeals of this court's decision. So the Colorado Secretary of State must have all appeals, including any potential appeals to the United States Supreme Court, right? We can still go up above Colorado. Resolved. We got to get all this stuff done, they say, before January 5th, when ballots must be certified for Colorado's March 5th, 2024 presidential primary election. And that's right around Super Tuesday. I think Trump's trial in the J6 case, which is, don't you just love this timing? It's wild. So Trump's January 6th trial is starting, I believe it's March 4th, so one day before the presidential primary election. So they're trying to remove him in Colorado on the basis of a so-called insurrection, and the day before Colorado people go in to vote, he also gets prosecuted and trial starts on March 4th in Washington, D.C. for an insurrection trial. So everywhere you turn, it's insurrection. Now, to aid the court in expediting this matter, says the removal team, a full brief on the one issue that petitioners seek to appeal is concurrently filed with this notice, and consequently, this notice does not endeavor to provide a full narrative description that's usually provided under the rules, right? If this is accepted and we can move forward, then we'll fill this out. They say here, we know that Trump, oh man, he filed his own notice of appeal. So he's upset too. He doesn't like this ruling either. And the court should consolidate these under the rules. However, we, the removal people, we request that all matters be expedited due to the impending deadlines. Like they want to go fast because if the ballot removal deadline comes and goes, then we'll see that this becomes moot. There's nothing else to really talk about if the ballots have already been printed and Trump's name is on there. So they're in a hurry. Okay, Trump is not in a hurry. They say here, expedited, we got deadlines, we got further appeal, like if you deny us, we're going up to the SCOTUS. And we've also got difficulties surrounding the upcoming holidays. And all this is also true. Like this actually is a thing, okay? It's hard to get stuff scheduled. There's judicial conferences and stuff, not only the holidays, but it's like suddenly everybody's got a judicial conference. You know what I'm saying? Can we schedule this? Sorry, the judge is out. Why? Conference. Oh, really? For 2 weeks in December? That's nice. So, it's just everybody suddenly kind of goes missing and things slow down around a little bit just by, happenstance. Very weird. Now, to that end, petitioner appellants, they request any additional briefings be ordered, meaning the removal people. We want any additional briefings here also on an expedited timeline. So we know Trump is appealing, and he's probably going to want long deadlines, but don't let him have them, okay? Give it to us. Make sure that we can go fast here. We also believe that expanding the word counts beyond those in the rule would be in conflict with the expedited nature of this case and necessary to resolve the matter as quickly as possible. So we're going to read Trump's basically simultaneous petition, and we're going to see what he says. And he's going to say, oh no, can we have more words, please? Can we have more time, please? Judge, we don't want to interfere with your vacation schedule, so you should definitely go enjoy that. And we'll just deal with this like in 2027. How about that? So final, they say here, petitioners, the removal, they seek review of the final order issued by Judge Wallace, who I have to admit surprised me. I was wrong on that. I thought that she was going to remove him because it's just the most interesting way that this was going to go, but she didn't. Surprisingly, even she's not, willing to push the psycho button like the rest of them. And entered on November 17th, which has been attached to this application. Now, the lower court's order, final order, resolved all pending issues before it and was final, and so no post-trial relief has been sought. Now, they say this court has direct jurisdiction over this case, saying that petitioner appellants request review of the following. This is the issue that is going to be on appeal. And again, we're not going to do a whole trial again, right? We're not redoing all of this. We're just really certifying this question and then asking whether this was determined to be accurate under the ruling of the judge. Question: did the district court, Judge Wallace, did she commit reversible error in ruling, complex question, that Section 3 of the 14th Amendment, which disqualifies people who engaged in insurrection, which she found, against the Constitution after taking an oath to support the Constitution, does not apply to presidents who engage in insurrection or to insurrectionists wanting to be president? Now, we're going to put a pin in this one, right? We're going to come on back to this one here in a minute because we're going to see how Trump frames his question, right? So you see how this kind of changes a little bit. It does not apply to presidents who engage in insurrection because they're presuming, right, Trump was found to be an insurrectionist under the judge, but it doesn't apply. Or let's get rid of the presidency stuff, really, and broaden that to insurrectionists wanting to be president, right? Kind of that's a question that we weren't really asking there, but you could extrapolate from that. Like the question is not, did somebody who, let's say, Jacob Chansley, for example, who I think is running for the House in Arizona or filed a notice of intent to do that. Shout out to Jacob Chansley there. The QAnon shaman, right? The so-called insurrectionist who wrecked America with his hat and his horns that was going to seize control of the whole country or something, idiots. Now, they are asking the question, what if he is successful in his run for office and then he suddenly turns around and wants to become president? Can he run for president? And that would be acceptable? Well, nobody really is asking that right now because the question is, first of all, did Trump commit an insurrection? She says yes, but he was a president when it all happened. And so does that apply to him and his conduct as the president, which is a little bit narrower of a question. So we'll see what Trump says in response. So they say, all right, transcripts of the hearing from the dates October 20th through November 3rd, which is a lot of the Colorado trial, which we covered here, will be necessary for this court's review. And if you missed the Colorado stuff, by the way, and want to get caught up, we have it broken down into a playlist on YouTube, so you can check that out. We're taken contemporaneously with the proceedings, and all of the transcripts have been provided. They tell us that all these people have certified it. Dylan Law Group is in the house and receiving some of these filings. Shout out to Harmeet, Dylan, and others. So these people have been certified as receiving notice of our appeal, so they're aware of it. Signed by Jason Murray for this law firm who's representing the removal individuals. Okay, so that is their appeal. Now, simultaneously to this, Trump also appeals his filing, and this is what this one looks like out of the Colorado Supreme Court. They write the following. Dear Colorado Supreme Court, President Trump also simultaneously seeks review and adjudication of Judge Wallace's final order, saying a district court decision may be reviewed and finally adjudicated by the Supreme Court of this state if either party makes an application to the Supreme Court within 3 days after the district court proceedings are terminated. And of course they are here. They say President Trump is a party in the district court proceeding. The verified petition originally named him as a respondent in the second claim for relief, and following voluntary dismissal of that claim in the district court, granted Trump's motion to intervene in the first claim for relief. So there was already a battle. There was a lawsuit. Basically, the petition removal people sued the government, and then Trump had to intervene. They were trying to, if Trump didn't intervene, who knows what they would have done. Maybe would have just, maybe not even had a trial. They would have just agreed to throw him off the ballot. Who knows? Who knows, in other words, what what Colorado would have done. But Colorado Republicans joined in, Trump joins in as an intervener. So the district court finally terminated the proceeding after we got the final order, which really split the baby in half. Is that the phrase? I don't know. Maybe that's not. But, both sides kind of lose. Like, Trump, you're an insurrectionist for sure. Like, you committed it, but we're not going to remove you from the ballot because it doesn't apply to you. Kind of like a technical thing. Then the other side's like, see, we told you he's clearly an insurrectionist, but we can't remove him because it's just technical. But maybe we can appeal it. Maybe that technicality will be reversed. So Trump says procedurally, the court confronts this matter for the second time. President Trump filed several motions to dismiss in the lower court, all of which were denied. And then President Trump filed a petition for relief seeking the review of the district court's orders. So Trump is basically saying, we've already been here, and this court denied that petition. Like, we could have already addressed this. Hello? Stating that it sought to maximize efficiency by considering all of the issues on appeal. So they said, don't appeal now, wait till the trial's over and then appeal all your stuff. And they said, all right, in that first appeal, before the trial started, they said this court explicitly reserved issuing an opinion on the merits of our relief. They said, we're rejecting you now. Trial is going forward. Bring your issues up together and we'll deal with it then. Following adjudication of several other issues and a 5-day hearing in Colorado, the district court and Judge Wallace issued its final order and denied the petitioners the relief they sought, meaning the removal team loses. They ordered the Secretary of Colorado to place President Trump on the ballot. Oh, and that must have hurt for them. But the district court nonetheless made legal and factual findings wholly unsupported in the law. So Trump, even though we win, we're unhappy with the other finding, right? That insurrection nonsense is nonsense, and we're going to be challenging that. And these errors demand review, especially if the petitioners in this matter also seek review of the sole dispositive issue upon which President Trump prevailed. Now, he's talking about the removal team. He says the removal team in the matters below have confirmed that they are also going to seek review of the adjudication of the final order. And so they just are, smashing these two things together. They're filing, and they're saying, are you filing? They're like, yeah, we're filing. What about you? You filing? Yeah, we're filing too. But when are you filing? Whenever we feel like it. How about you? Whenever we feel like it. And you're like, oh, well, how about, they're all pointing to each other. So they say President Trump seeks review to ensure that if this court takes up this case on appeal, if you're going to take their petition up, that you take our petition up and you consider the full scope of the constitutional, the interpretive, and the evidentiary issues. To be sure, the district court, Wallace, grounded its ruling on a correct textual analysis of the U.S. Constitution in Section 3. This was perfect, Judge. Nice job. When it held that Section 3 of the 14th Amendment does not apply to the president. But even though she was pretty good on that issue, nicely done, Judge Wallace. Really fooled us on that one. You nonetheless committed multiple grave jurisdictional and legal errors. But not on that first part, though. That first part was like perfect. Well done. But now then you screwed it up. And those include adjudicating. And by the way, I know I'm kind of being jokey here, but the other side's saying the opposite, right? They're saying, oh, no, your insurrection clause, that was like perfect. Absolutely outstanding. Definitely an insurrectionist. But you're kind of dumb when it comes to the Constitution. So they say here, Wallace, you committed multiple grave jurisdictional and legal errors. Those include adjudicating constitutional issues in a proceeding under Section 113 and then creating new, unprecedented, and unsupported legal standards in applying Section 3. You just kind of made stuff up. Importantly, Trump's defense says this matter on appeal encompasses multiple issues of first impressions that affect Coloradans and all Americans' ability to select a president, particularly if Trump is barred from the ballot. It would be kind of insane, honestly, which is, I think, is why the judge is like, I'm not going to do this. Like, I know I'm going to get in trouble at my cocktail parties around the holidays. All the people are like, they walk up to everybody else in the circle and they're like, would you guys like more hors d'oeuvres? And they look over at Judge Wallace, like, no hors d'oeuvres for you. She's like, I'd like one of those pieces of cheese. No cheese for you. So a full review requires analysis of the errors made by the court below. In fact, we have identified 11 issues for review. Trump's lawyers recognize that this is an unusually large number of issues, each of which itself is worthy to stand as a single issue on appeal. So this judge is, man, she's pretty bad. 11 problems, and we know that like identifying 11 problems is kind of a lot, but we got to bring them up. But if this court chooses, if you choose to exercise discretionary review of Judge Wallace's final order, and if you accept this appeal from these petitioners, well, if you want to open this can of worms, guess what's going to happen? A comprehensive review of the district court's errors is necessary. We're going to really dig into this. Pandora's box is going to be opened. Now, those errors affect weighty public policy considerations and serve as faulty interpretation of important constitutional issues. And as the court earlier noted, considering all issues issues in one proceeding, as you said earlier when we were here before this all happened, will maximize efficiency in the event this matter is appealed. So you said you want us to bundle it all up. Well, guess what? We're here. We've got 11 issues to bundle up. Now, because of the complexity and the number of issues that are involved in this case, as well as the possibility of further review, President Trump asks this court to set a briefing schedule and also to increase the allowable word limit to 19,000 words. Oh yeah, we love those extra word limits. Can we have more pages, please? Because we're going to need more time to fill those pages up, you know? And we need those 19,000 words for both opening and answer briefs and 8,500 words for the reply brief. This will allow for full discussion of the issues before this court. Now, I don't know what the regular, limits are in Colorado, whatever the word limits are, but hopefully it's a lot bigger because we know they don't want it. The petitioner removal team, they're like, can we just keep it to like 2 pages, please? We have to go very fast and get him off now. So they say this is the final order that we want to appeal. Court's final order issued back in November. This case have a couple questions. Are you requesting any additional time? Nope, not right now. Here are the possible issues. Now, again, I want to point a pin in how they framed it versus how Trump's team frames it. They say the district court held a 5-day hearing beginning October 30th, but under section 113, it prohibited discovery and allowed only 5 weeks to prepare a defense. So we had no defense at all, meaning these petitioner people have obviously been preparing their case for probably years. Like, I would estimate if I were plotting something like this, I would try to pick the best forum, try to find the best judge, come up with a rock solid case, get the best experts, make sure your PowerPoints are all nice and beautiful, right? Have everything lined up, file it so that you can exploit the deadlines and really rush the defense in their response. Like, Your Honor, like we filed it. Well, you could have filed it a long time ago. Well, it wasn't ready yet. You just time it and then the judge favors them and the defense is on their heels. This is the same pattern that we saw with prior election stuff. Back in 2020, we're up against deadlines all the time. And the defense or the petitioners, right, the courts will orchestrate it to hold it against Trump. If Trump files something, they say, sorry, you're out of time. You don't have time for discovery. If they file something and Trump responds, they say, sorry, don't have enough time. You can't have discovery. Everywhere you go, right, Trump is kind of on his heels because they are the party doing the attacking. Now, this court's rulings, they say, directly prohibit litigation of constitutional claims in a section 113 proceeding. In other words, the judge heard claims that she should not have heard because the district court is limited to ordering compliance with the election code. That's it. And because section 113 procedures are incompatible with adjudication of constitutional issues. Love that. That is so good. And it feels absolutely true, right? Why can Judge Wallace expand the scope of just election litigation to adjudicate an entirely new novel constitutional issue that nobody's ever heard about? And we saw what this trial proceeding looked like in the Kerry Lake trial. We covered that here, live, a lot of it. And we saw that there are different rules, right? It's not even really a civil trial. It's not a criminal trial. The standards are much lower. The burdens are much higher for the challenging non-moving party. And the timelines are a lot more compressed. It's a lot less of a procedural protection than you would get in other types of litigation in this country. So why then, with those minimal protections, can the judge just essentially say, she didn't do it. She could have. He can't be on the ballot. What kind of procedures are those? Now, they asked this question. Should the district court's opinion be vacated for lack of jurisdiction? In other words, this whole thing should just go away. Yes, she ordered that he should be on the ballot, but he should already be on the ballot. And this whole dang thing should just go away. Should the opinion be vacated? They also say the district court ruled, Judge Wallace, that Section 3 did not apply to the presidency because he's not an officer of the United States. But the district court nonetheless applied Section 3 to Trump, finding that because he, quote, engaged in an insurrection, that she made the finding, right? She said, no, he did engage in an insurrection. Okay, but you just said the 14th Amendment doesn't apply to him. So how could you say, why would you even do the analysis on engaging in an insurrection if you say it doesn't apply to him? It's logically inconsistent, and they're pointing that out. Now, should these findings be vacated because the district court self-admittedly lacked the jurisdiction to apply this to President Trump? Great question. We'd love to know what the court says about that. Another question. The district court correctly held that Colorado law, nor any other provision of the election code, grants the secretary authority to investigate or remove a presidential candidate under Section 3. But the court nonetheless ruled that it could adjudicate candidate eligibility under Section 3 and issue orders requiring compliance with the 14th Amendment. Can a district court, in this case in Colorado, under Colorado law, determine candidate qualifications under the rules, even when the election code says that there is no authority to order that relief? In other words, the people who tried to remove him brought a claim under the law. And then the judge just said, you know what? Maybe he is an insurrectionist. And we're saying, does the law say that they can bring a claim to remove an insurrectionist from the ballot? And they said, no. The judge said, I can do that. Now they're saying, okay, well, let's find out. Now, Congress has not authorized, they're pointing out, the state courts to enforce Section 3, and the U.S. Constitution specifically grants Congress the authority to implement the provisions of the 14th Amendment. But the district court held a hearing and, for whatever reason, made findings under Section 3. Now, may a state district court adjudicate Section 3 disqualification without Congress authorizing the statute to do that? Another good question. Now, as a reminder, right, they only had the one question over here on their end, where they were just saying, did she screw up on that second portion? Did the district court commit reversible error by saying that the 14th Amendment doesn't apply to Trump? So we continue. He says, does presidential disqualification under the Constitution present a political question non-justiciable in a state court, as multiple state courts have held? In other words, should the people be able to vote on it? Okay, you can't file lawsuits against the government because of political questions. Okay, so sometimes people will ask here, Rob, can we just sue the government to challenge them for violating our rights? Can we just file a lawsuit against them for violating this right? It's like, I wish, man, I wish. But no, you can't, right? It's a political question. The courts have just said, nah, if we allowed that as a matter of policy, everybody would be suing them for everything. So they call it a political question. If you're unhappy with some policy, you got to really go vote for candidates who will work against that policy. So here, is this disqualification something that some district court judge can just decide, or is this a bigger issue? For the first time ever, they say the district court found that the phrase engaged in, as used in Section 3, includes the word incited. Never learned that in our law before. Nobody's ever determined that. She did. Was the district court correct to define engaged in so broadly? The district court, Judge Wallace, also ruled that President Trump and his political speech, quote, incited violence, even though the words he used never advocated violence at all. Instead, Wallace found that Trump's and his supposed intent and the effect of his words, right, sort of was reading his mind, and the effect that sufficed to render his speech unprotected. Incitement. Now, did Wallace err in its application of the First Amendment standards to Trump's speech? Did she do good analysis there? Did Trump's speech actually mean that he broke the standard that protects free speech, the Brandenburg standard? This is actual incitement? Good question. Now, the district court relied upon President Trump alleged his delay in deploying the National Guard. She said Trump was just delaying, dilly-dallying, like Liz Cheney said. Now, she said that that was a basis to determine that Trump recklessly endangered people and so-called engaged in the insurrection. The Supreme Court, they're telling the Court of Appeals, the Supreme Court in Colorado, hey, reminder, SCOTUS, they has repeatedly made clear that courts may not second-guess a president's discretionary decision-making in this area. Obvious. And we've been making this point for years now, ever since Liz Cheney said, he should have, like, driven over there and beaten him with a broom or something. Like, whatever she said Trump should have done, it's not her decision. She can't substitute her discretion for his, because she's not the president and never will be. Did the district court's decision improperly invade the province of the federal executive branch? How dare they second-guess him? Now, the district court defined insurrection through Judge Wallace as 1, public use of force or threat of force, 2, by a group of people, 3, to hinder or prevent execution of the Constitution of the United States. They say, well, that's curious. Where did that come from? Because we have this thing called precedent in the law. We're supposed to follow it, meaning you don't just make stuff up in your courtroom. But they make the point, this definition, however, is new, and it's without precedent. Did the district court adopt the proper definition of, quote, insurrection in holding that the events of J6 constituted an insurrection, right? And this is where we were getting concerned about this. It's like, is she defining things that are going to make their way up and make their way into the law? Are they going to try to use this stuff and, like, this definition that a state court found he committed insurrection as some sort of evidence in his criminal cases? We'll see. Now, when particularly important individual interests, such as constitutional rights, are at issue, they say the proper standard of proof requires more than just a preponderance of the evidence. Okay, we have constitutional protections, like if they're gonna dump all over your right to remain silent, right? You go through the Miranda process. It's important. We have constitutional rights for a reason. Not supposed to just censor people and ban them from social media platforms and have the FBI twisting arms to do it. And you're not supposed to just remove people from the ballot, because we have a constitutional right as citizens of the state to vote for the people that we want to. And there are many people who want to vote for Trump. But the district court really is not applying to any standard, right? In a regular civil trial, not an election case, whatever this was, you have preponderance of the evidence. If it's more likely than not, the evidence tends to show it's more likely than not that the claim is met, are sufficient. We raise that dramatically in a criminal case because your constitutional rights are absolutely being challenged there, including your freedom to walk around society. So we raise the standard standard of proof to beyond a reasonable doubt, which you've heard about. A lot higher, meaning if there's any doubt based in reason about a person's innocence or the guilt, the evidence presented, then they are not guilty. Very high standard. But what the judge did in this case is just like, well, I don't know, it's an election. Tell us whatever you want to. The district court rejected this standard, preponderance of the evidence. More than that, reasoning that liberty interests at stake do not even require a higher standard of proof. No. Does potential disqualification, Supreme Court, does it under Section 3 to hold federal or state officials, does it implicate important liberty interests or not? Like, does our right to vote for somebody on a ballot that we want to vote for, does that matter? Does that require due process? Does it require a burden of proof greater than preponderance of the evidence? Like a judge just like wake up one morning and just, by judicial decree, I find insurrection. Do we have any safeguards or no? Let us know. Even before the J6 committee began its work, says Trump's team, every committee member previously determined, every one of them, Cheney, Kinzinger, all of them, through public announcements and an impeachment vote, they stated the supposedly, quote, obvious fact that President Trump, quote, incited an insurrection, right? It was already done. It was already concluded. The committee contained no members who disagreed, allowed no minority staff, and hired a television producer to package the committee's conclusions for maximum political impact. Now, did this bias, highly unusual procedures with no adversarial even questioning, and this structure, and the report's extensive use of what they say is multi-level hearsay, does that render the report inadmissible to serve as the basis for Judge Wallace's determination that Trump engaged in an insurrection? Like, in other words, is that evidence terrible? We know the answer to these questions. We'll have to see what the Supreme Court says. They say transcripts are necessary. You can review all of these things. These are the people who are petitioning. We know their names. And they tell us Trump is intervening. Here are the attachments, a final order, a $223 filing fee, and copies have been delivered. Over to the Honorable Sarah Wallace, who made very good finding on the 14th Amendment issue, not so good on the insurrection issue, but this is signed off on by Scott Gessler and Jeffrey Blue, two attorneys for Donald J. Trump. Now, this is all going to be landing in the Colorado Supreme Court, and they, of course, are accepting this and giving us some scheduling. We're going to hear from Trump's attorney on the Colorado case in a minute, but you see, this is what the order of the court looks like. They say, all right, we got everything. Upon consideration of Trump's application for review and the petitioner's application for review, here is what we are ordering. We accept the cross applications for review. Now, given that we filed our opening briefs, they say petitioners, they filed their opening brief. They already did file his opening brief, so that has already dropped. Trump shall file his opening answer by November 27th. Then the removal team shall file their reply by December 1st, Trump's reply December 4th, and Trump doesn't get his way. The opening answer brief and the answer reply, 9,500 words in the opening answer brief and 5,700 words in the reply. Now, we've got a couple, amicus briefs are being granted. The Constitutional Accountability Center and constitutional law professor Mark A. Graber wants to file his brief, and so they've got some deadlines on that. Oral arguments are going to be scheduled December 6th, so mark your calendars and be sure you are subscribed, my friends, because we will be covering what happens here. Oral arguments, 1 hour each side. Counsel needs to check in. If you file written briefs, do so accordingly. Amicus filings will not be part of oral arguments, and the court will not extend the length of oral arguments to accommodate the amicus filing. So that is what it looks like, and of course, we're going to be here to cover all of that. We're going to see who is there arguing on behalf of the Trump defense, but this is an exchange between one of Trump's lawyers who was there arguing the hearing in Colorado and this woman from CNN. Let's listen to what it sounded like as she was asking him about the next steps. Of course, Trump is victorious on the removal question, but lost the insurrection question, and where does it go from here? This is Scott Gessler, who is one of the Trump attorneys.
The fact that she does go into such detail and is now the first judge to ever say that Donald Trump engaged in an insurrection, do you still really view this as a win here?
Yeah, could be on the ballot.
You know, we can't stop the judge from saying things like that and still ruling in our favor. But I will tell you, she also said that the First Amendment protections don't apply to President Trump the way they do to everyone else. We think that's flat wrong. So there are a lot of problems with that analysis. Maybe that will wind up contesting it, maybe not, depending on how the appeal comes out. But at the end of the day, she ruled for us, properly so, is her opinion on what happened. But it has no legal authority at all because her ruling.
But I guess some people would read this and see where she says that he acted with specific intent to incite political violence, directed at the Capitol, that he not only knew about the potential for violence, but that he actively promoted it and incited it on January 6, 2021. And they'll say, okay, yes, he is staying on the ballot, but the judge also is tying him to all of this activity activity, saying that he was responsible for what happened that day, and ask how this is a victory for the Trump team.
Look, part of the problem with that analysis is that what she did is she took the January 6th report, which was a wholly one-sided approach used to attack President Trump directly and politically. And she imported that whole thing into the case itself. She viewed that as reliable, which is, I think most reasonable people would view that as absurd. And so she relied upon that to make some of those
decisions. There are people who would not agree with that.
The foundation of that is rotten. I'm sorry?
Yes, there are some people who do not like the January 6th report. There are a lot of people who believe its findings. I mean,
Great question,
I saw you
Caitlin.
making this argument
Liz.
in court, saying that you didn't believe that should be something that, you know, the other side was basing their argument on here. Is there anything, I guess, in the facts that she's laying out here and the statements that she's laying out here that you dispute about Trump's behavior on that day?
Absolutely. He did not act with intent or specific intent at all. We thought the evidence was very clear that he made efforts to ensure he authorized the National Guard to make sure that they were available to prevent this type of violence. If you look at his actual tweets,
he didn't authorize the
and
National Guard on
speeches
that
and
day.
statements, he did.
Well, Kash Patel, his former aide, testified that as one of your witnesses here, but when he was asked, you know, documentation or any evidence that Trump had done that, he didn't provide any.
Yeah, well, there were two. There was a second corroborative witness, Katrina Pearson, and in fact, the plaintiffs, they're called petitioners, brought in
But
a
Katrina
tweet
Pearson didn't
themselves.
work in the White House.
Allow me to finish. A tweet from an advisor to President Trump that actually referenced President Trump's efforts to make sure to authorize the National Guard. It was their own evidence that they brought in that referenced that. So I don't think it's appropriate to say that he never authorized. That's just not fair. And I don't think the evidence leans in that direction. I thought we put on pretty strong evidence. And she can say she doesn't believe people, but just because there's not a specific written document doesn't mean it didn't happen. And
there are written documents before that. Okay, we do have a notice that there was some, verbal conversation about deploying the National Guard in D.C. How do we know that? Is because Muriel Bowser rejected them, right? She sent a letter back. We have that letter. We put it up on the screen many times here. She says, don't send National Guard into my city. So Trump was trying to do it on January 4th or 5th. She sent the letter on the 5th. It is in alignment that he would want it also going out on the 6th. Well, we told you, you want him now? And then they delayed, and we have Stephen Sund to corroborate the back end of that. Okay, so Trump was trying to be proactive before January 6th. Stephen Sund, former Capitol Hill chief of police who got fired essentially after January 6th, confirms that on the back end, he was calling around for a bunch of stuff. Can I have permission? Can I have permission? Can I have permission? Delay, because they wanted it to happen. So the idea that Trump or the campaign, the Trump administration did something in the middle of that makes total sense as well. But they just pick little things and they say, well, where's the documents? Well, we got the letter from Mayor Muriel Bowser. Why didn't she accept it?
frankly, part of the problem with this entire hearing was that we didn't even have the time or the ability to send out subpoenas and get type of witness testimony and look at other types of documents to be able to make our case. So we were very limited on what we were able to do. So to be able to say, well, you didn't have enough documents, part of that was the truncated or compressed process, the lack of our ability to compel people to talk to us, the lack of our ability to actually get documents unless someone volunteered them to us. So there are some real problems along those lines.
Well, I haven't seen any.
Process itself.
I mean, this has been.
We thought there was very strong evidence.
This has been investigated time and time again, including by this committee. And I mean, Donald Trump himself did not testify here. He blames Nancy Pelosi for calling the National Guard that day, even though it was in his authority. But I do, I looked at what you said on the first day of this trial. You said you believed the judge was biased and that she should recuse herself. Do you feel differently now based on this outcome tonight?
Well, I mean, what I said initially is she had contributed money to an organization that was specifically dedicated towards removing politicians that they claimed, that this group claimed, engaged in an insurrection. So the very purpose of the organization she contributed to was
before she was on the
already
bench,
made
though,
a
right?
decision that showed her support.
But she was running.
Well, not quite. She had already applied, and I believe she had been nominated but not yet appointed. Plus, it was within the past year. So whether you're on the bench or not, if you do that
Rules
within the
apply.
past year, usually attorneys sort of look at a year as a rough deadline for
She knew where
sort of
she was
viewing
going
things
when
in
she
the
did it.
past. And it was still pretty fresh. And so we had deep concerns about that. I'm not necessarily here to relitigate that about the judge. At the end of the day, we're respectful that the judge made the right decision. I understand she threw a lot of shade on President Trump, and we're not happy about that, and we disagree with it. But at the end of the day,
But I
she
guess
at
my
least,
question is,
and we're respectful of this, that she's respecting the democratic processes.
are you saying that you accept the ruling, but you're rejecting her findings here? It seems like you having it one way and also the other.
It's not actually. We'll see what he says, but we just went through the appeal. They're saying she didn't have jurisdiction to do any of this. Essentially, this case should have never gone, and they've been very consistent on that. And even in their appeal, he's making the point to the Court of Appeals to say, hello, she doesn't have jurisdiction over any of this, and they just said, wait wait until it's over and consolidate it. So no, Caitlin, they've been consistent from day one on this.
Not at all. I mean, we accept her jurisdictional, her conclusion that the 14th Amendment doesn't apply to the presidency based on its plain text and the history as well. We certainly accept that. The other stuff she wrote in there, frankly, is not germane to her decision. Courts, attorneys will call that dicta. In other words, it's just sort of superfluous excess language that didn't really make a determination how she ruled. So, at the end of the day, she said that. We disagree strongly with that, but she also ruled in our favor. And, at the end of the day, that's what we're satisfied about, that President Trump will have the opportunity, like everyone else, to make his case, and that voters will be able to have the opportunity to vote for him if they want to. And that's what democracy is about, and the judge respected that.
Right, instead of pulling him off like cheaters.
Still quite a scathing ruling saying that he acted with intent to incite political violence. Scott Gessler, the
intent. Yeah, okay. So, it's the same people, right? Why didn't Trump protect everything? Why didn't he protect the Capitol? I remember, if you rewind the clock, these were the same people saying Trump is going to try to seize power. Don't you dare let Trump move the military into the Capitol or else he'll seize control. Right? And they were warning us like, oh, he's never going to leave the White House. And so if Trump moved the National Guard in, they would have said, see, he's trying to seize the country. So he's damned if he does, damned if he doesn't. And, this is CNN doing the usual thing, trying to beat up on that guy. He handled himself very well there. And the appeal seems quite strong. It's like, why did this judge handle this case right now in this forum with these standards, with these issues at stake? Our right to vote for a candidate was almost stripped away from us by Colorado. And it still might be. We'll see what the Supreme Court does there. Trump's filings have been submitted and they've got deadlines scheduled for more. So we'll be here continuing to cover it, my friends. Thank you for joining us. Thank you for subscribing and going to robertgovea.com to sign up for our daily newsletter. That's where you can get all of these segments, all of these PDFs that we just reviewed. You can access them and get the stories delivered to your inbox so you can forward them on to friends or family or anyone else who needs to know about this stuff as we continue to cover the Trump litigation here in detail. We'll look forward to seeing you on the next one.